Hello, I'm J.A.A. Purves.
And my name is Paul F. Blewett, and we are estate planning lawyers located in Santa Barbara, California, at the law firm of Penner and Purves.
And today, if you live in the state of California, we are making you a proposal and an offer.
We are offering to work with you one-on-one, in person or over video, to carefully and systematically design and create your family's own personally tailored estate plan. We specialize in trusts and have dedicated ourselves to this work because there are too many families who are never educated about the estate planning strategies that families need to have the foundation both to be legally protected and to thrive, to grow stronger, closer, more resilient and long-lasting as families in a time of increased rootlessness, flux, disintegration, economic instability, and political polarization.
And so, this is our proposal. Proposition. The act of creating your estate planning will strengthen you as a family, plan for your family's security and long-term care, and enable you to build the important relationships that families used to have in the past, but have been all too often deprived of in our increasingly individualized, isolated, and non-stop media streaming 21st century lives. While creating your estate plan might sound like a lot of work, that's where we come in. We will do almost all the work for you to get everything set up. From your end, it will take a low time investment, essentially amounting to a free educational consultation with one of our estate planning lawyers, and then, if you then engage us, a follow-up trust design phone call and a final document signing meeting with a notary that you can easily do at your own convenience.
For many of our clients, because of our thorough, efficient, and systematic process of walking our clients through their strategic decision-making, this ends up being what amounts to about 3 hours of time.
Approximately 90 minutes for the initial free consultation and plan design, approximately 90 minutes for document review and walkthrough of the details, and approximately 60 minutes for document signing, notarizing, and finalization. After which, your family will be legally protected and your estate plan will be in place.
So if you are an adult as early as in your late 20s, there are many important reasons to conclude that you have already been putting this off for too long. What would be the dream outcome of finally getting the legal planning area of your adult life taken care of?
If you do your estate plan when you are young, you will have the peace of mind of knowing that you have a legal and financial planning strategy mapped out with all the pieces in place necessary to, number one, protect and take care of your family if something happens to you. Number two, start the momentum of a family wealth building project that you can be confident of. And number three, give you the security to know that your children will be educated and raised with the values you most care about, sharing with them no matter what happens in the future. This will be a source of both security and strength that you will not have without the necessary legal documents.
Even if you complete your estate plan once you are older, you will have the peace of mind of knowing that, one, you have provided the education, tools, and resources to your family so that they have both the protection and opportunity to flourish in living good lives. Two, you have secured and maximized the tools your family will use to carry on and taking care of, loving, and supporting both you, if you have a time in your life of incapacity, and those you love after you are gone. And three, that you will have left a legacy to your heirs that will be both a protection and a growing force that they can wield to accomplish good in the world for generations to come.
This is contrary, of course, to the default, because if you do not have an estate plan in place where you have made your own decisions, guess what? You do still have an estate plan. Did you know that?
That would mean that you have the government's plan. And the government's estate plan for you includes a collection of bureaucrats, social workers, clerks, lawyers, and judges, all complete strangers to you and your family, incurring extra costs, exercising power and control over your family, you and your family's money, and perhaps most alarming of all, if you have minor children, even over your minor children's future and welfare. You probably do not need to guess that the government's plan for you also involves taking sizable chunks out of your money and estate in the form of probate court fees, attorney fees, and every possible kind of tax that can be applied to your money and property, so that your heirs ultimately get less whenever the years-long probate process is finally finished.
But you don't have to have the government's plan for you. One of your liberties as a citizen of the republic in which you live is to make your own decisions for your family's own estate planning. So, if you haven't made your own decisions to create your estate plan yet, or if you haven't actually worked with estate planning lawyers whose passion is to help educate you and inform you in order to ensure that your estate plan has actually stayed up to date and actually works, what are the reasons you haven't done that yet? I can tell you, as an aside, that the ironic thing about the most common objections to completing your estate plan is that all of these objections are actually reasons for you to get your estate plan done now and not put it off for later. Therefore, again, what are the objections that have led to your not having an estate plan? Objection number 1. Estate plans are for rich people, not for little old me.
The truth of the matter is that the wealthiest families are the families who could most afford to take the hit of the costs of probate and the taxes that result from not doing any legal planning in advance. For example, a family with a net worth of $50 million is going to be affected much less by getting their estate docked by 10 or 20% than families with net worths of $1 to $2 million who suffer the loss of $100,000 to $200,000. It is the normal middle-class families who benefit from being protected from probate most. It is the hard-working families with net worths of less than $1 million who suffer the heaviest losses in probate court.
Objection number 2. Note to self. I can do it later. I'm too busy right now. I have too much work to do this month.
Being too busy right now is the exact reason why you should complete the legal planning area of your life today and not tomorrow. Completing your family's estate planning is a permanent change of added stability, structure, security, and peace of mind. Most things that you wait to do because you are too busy never get done. You know why? Because you die. Studies show that only 30% of Americans do any estate plan of their own. That means that 7 out of 10 of American families send their families into the stress, delay, government bureaucracy, and expense of probate, and often of additional taxes. If you are a smart, hardworking, responsible adult that truly loves your family, be one of those 3 out of 10 Americans who do differently. As other sharp business leaders have said, you don't wait for the outcome to do the thing, you do the thing to achieve the outcome. Don't put your family under the power of strangers.
Objection number 3. I don't trust lawyers. I can do it myself, or I can just have a freewills.com or AI do it for me.
The problem with cheap, automated, and free downloadable cookie-cutter estate plans is they were made by people who don't know you or your children, who don't have any idea who you are and what your family's needs are, who do not care, and then pretend that you have the knowledge and training to be able to decide yourselves what trusts and estates law apply to your family. Just because you don't have the knowledge, just like I don't have the knowledge of a doctor or a CPA or an airplane pilot, doesn't mean that you aren't smart enough to learn. The question is whether you have time to learn. Try to take the easy, cheap, free lunch shortcuts if you want, But remember, you get what you pay for.
Objection number 4. But it's too expensive. I could get a cheaper one of those.
The only, and I repeat, only reason you would hire an estate planning attorney to create an estate plan for you is if, after consulting with that attorney, it was clearly demonstrated to you beyond any doubt that what your family and estate would save by having that estate plan in place will far exceed whatever you pay to the attorney for working for you to tailor it for your family's unique circumstances. Not only that, but true estate planning is not just about money, unless you are just about downloading a one-size-fits-all auto-generated one created by an algorithm. Good estate planning is about relationships and tangibles, including the values of human, intellectual, and spiritual capital. It involves questions of life and death and flourishing for the people you love most in the world. It's worth making a reasonable investment to get it right. I can tell you that we pride ourselves in building in values and intangibles in your estate planning decision-making throughout, something that you will not find in most law firms.
Objection number 5. It's a lot. I won't admit this out loud to anyone, but it's just too much work. Besides, it's asking me to think about my death. I'm going to avoid that.
2 quick principles. First, if you work with our law firm, we have spent so much time systematizing the different estate planning tools and strategies that exist on the map for you to utilize in maximizing your protection and wealth building for your family, that we can talk you through the basic decisions you need to make in less than 2 hours for a standard family trust and estate plan. In other words, we have already done and will do almost all the work for you. That's our job. Second, estate planning is not by any means primarily about your death. It is instead about relationships, relationship building, trust, protection, and delegation, and caring for your children. Out of all the estate planning decisions that you will need to make, easily 2/3 of those decisions will be about your lifetime, not about your death.
Objection number 6. Estate planning is for old people. I'm still young.
So said the millions of young parents in history who died young, leaving minor children without designated guardians to the whims of the bureaucratic probate court system. Don't be one of those people who insist that it would never happen to me. Besides, for parents who start their estate plans young, they have the advantage of compounding momentum over time in their planning, strategy, and relationship building that people who only get their estate plans done at 60 or 70 will never have. Always better now than later. Also, as ironic as it may be, many a stroke and a heart attack are caused by levels of stress and pressure a person feels day to day. The cause of stress and pressure is that nagging, insistent knowledge that legally your family is exposed and not protected. That causes more stress, and that's another reason to die sooner. Get the peace of mind of knowing that your family is legally protected by your estate plan documents, and perhaps you'll even live longer.
Objection number 7. My kids shouldn't be relying on their inheritance. I don't want to end up creating trust fund babies.
Well-designed estate plans and good parenting never result in trust fund babies. Don't be a parent who abdicates the responsibility of proving to your children that first, you care about their being educated in prudence and sound financial practice, and second, that they are capable to raising your family's standards and doing even better than you, and that you are going to do everything in your power to give them that opportunity. Isn't that a better alternative than just shrugging your shoulders and acting like you never were trusted with the blessing of raising your own children rightly?
Objection number 8. No one ever told me I needed this.
We just fixed that. Anyone in the state of California with assets that exceed $208,000 needs this. Think of it this way. If you do not have an estate plan, then if you have minor children and something happens to you, your children will be picked up by CPS until a court process makes an award of guardianship to a person you may not have selected. If you do not have an estate plan, then your family and your estate are headed straight to probate court after you die. an expensive process that often takes a couple of years to complete. And if you do not have an estate plan, then you also have not conducted the exercise of thinking and talking through together what people you trust most and what friends, family members, and professionals you would delegate support and backup roles to ensure your family members are cared for and protected, and to ensuring that your savings and properties will not quickly be spent, lost, or sold in a way that you would not agree with. If that sounds like an overwhelming thing to do, it can be, and many people don't know where to start. And that's where we come in. Guiding you through this decision making and helping you reason through your alternatives in an efficient way is what we are practiced in doing, such that we help our clients do a first initial setup within less than a couple hours. Then imagine the relief of the following results. Your children will not be at risk, and you will know who has legal authority to care for them, even for a couple of overnights if there was ever an emergency. Your family will never have to undergo the expense, stress, and delay of probate. And you will have begun an initial setup that provides clarity and structure for who your most trusted relationships will be and for what you will be asking them to do if needed when your first big life emergency occurs.
Just imagine having all of that done and taken care of in a way that is straightforward, clear, and makes sense to you. Hence, given all that we have shared with you, here's what we propose. Call or text us at 805-965-0085 to book a free estate planning consultation. If you live in Santa Barbara County, we would be delighted to meet with you in person at our physical law office. If you live elsewhere in the state of California, we will happily schedule a video consultation with you. During that consultation, we will educate you as to estate planning alternatives and strategies available to your family, and we will summarize the flat fee only packages from which our clients choose when they decide to retain our law firm to do the work of creating the estate plan for them that their family needs. Then, after the consultation, if you decide that retaining us to do your family's estate plan for you will save you money and protect your family, you can start the process with us right there and then. If you decide not to, we will still be happy just to have shared the value of the educational consultation with you. Now, we are a small boutique law firm, and that means that we have limited our business growth and scaling as to size and quantity, so as to focus our time, work, and dedication to scaling in the quality of the services we offer our clients. And that means that we only have limited slots, an average of only 4 to 6 per month, that we can take through our select and personally tailored one-on-one estate planning process. If you want to get this done sooner rather than later, book your place on our calendar before that slot gets taken.
So just call us or click the link below to book an appointment. We look forward to working with you and answering any questions you have.